Thank you for the great introduction and all of the housekeeping notes. If you have any admin concerns, let Jeff know in the chat. Once again, I'm Allison Hertz. I'm an attorney from K. Bender Rembaum in our Palm Beach Gardens office. Obviously, I'm your corporate counsel type for condo and HOA law. As Jeff mentioned, I'm board certified by the Florida Bar, who administers attorney licensures in condominium and plan development law. I was board certified in the inaugural year, and I continue to be very active in the Florida Bar's condo committee. We work on a lot of legislation and other issues affecting associations. I had a lot of participation regarding some of the Surfside issues last year. As an aside. But let's get started today. I know we only have a limited amount of time, and I typically have trouble finishing these courses because I like to talk a lot. For those of you who have listened to me before, thank you once again for joining us today. And we're going to talk about conflicts of interest. Obviously, that is the title of the class today. But some of the initial slides that we will show are related to fiduciary duty and acting in the best interest of the association, because that's really the sort of bedrock of this matter. The flip side to conflicts or improper activity is fiduciary duty. That's the standard here, that you are a fiduciary if you're on the board to your members. And that's what we need to uphold here. So I'm going to share screen. Bear with me because sometimes this is a little bit difficult for us lawyers. I think we got it, but I got to do the share slideshow from the beginning. So are we? Let's see. I think I might need to switch screens here. Jeff, what are we seeing on the screen here?
We see the notes on the left and the big
let me
slide on the right.
All right, let's get this going. Is that better now?
Yes, there you go.
Okay, here we are. So let me get my settings set up. Okay, we're in the right spot. You're in the right spot. I'm in the right spot. We can get going now. Conflicts of interest. As I mentioned, fiduciary duty. We don't want to forget here that as a board member, as an officer of a Florida Condominium Association, Homeowners Association, Co-op Association, although we're not focused on co-ops, unfortunately, today, you are running a corporation. You are an officer and director of a not-for-profit Florida corporation. Sometimes we lose sight that your association is, a condo, a homeowners association, but that's a corporation. You're incorporated under Chapter 617 Florida Statutes, the Florida Not-for-Profit Corporate Act, and you are running a company. You are legitimately on the board of a corporation here. So while a lot of the things that you consider as a board might not feel like you're a corporate executive, right? You are running a company and you need to take it very seriously as such. When I talk about all these fiduciary duty concepts, and really a lot of the conflict of interest matters today, we are talking about them from the perspective really of dispelling common misperceptions. We're not trying to put people on blast here today or give a lot of ideas that something's wrong in the industry or with your association, because the vast majority of board members, officers, and associations run smoothly, effectively. There is really a very little nonsense going on in the associations that, frankly, I deal with. Yes, we all know it's out there. We read the news and we hear about it from time to time, but most of the associations are very well run, and a lot of these, improper and sometimes unlawful activities are not occurring. So my perspective here during this presentation, and we'll try to weave it throughout, is to really dispel a lot of the common misperceptions with respect to conflicts of interest. I saw in the Q&A those who immediately submitted questions, which I see. A lot of these were very interesting to me, just the ones that have already been submitted, because there are so many common misperceptions concerning these type of issues. So we'll backtrack a little at this point, going back to the fiduciary duty issue. And the brief way of describing fiduciary duty is that the association officers and directors must act in the best interest of the association. That's a very brief and somewhat oversimplistic way of stating it, but I think it's effective and it's true that you have to act in the best interest of the association. You are serving your membership as on your corporation board, and you're not doing that in your own self-interest, although sometimes you may have an issue, and I'm speaking to board members really right now, and obviously unit owners who have concerns, that you may have an issue that's important to you and you want to see that issue through, and that is in the best interest of the association a lot of the time. And sometimes things that people perceive as a conflict really are not conflicts. So we'll get into all of that stuff. But as just a basic premise, I want to direct you to a lot of the statutes which discuss these issues. This slideshow is a very, very great resource for you. We have many courses at KBR and all of them are great, but this particular course, we have a lot of statutory citations, and I don't mean to overload you on text here, but I like to include the full cites to many of these statutes because you can use this as a reference as you go forward in your service to the board or in your active, if you're active in your association as an owner on committees, managers. You can use this as a quick reference and find the statutes that relate to the points that you're interested in. So we'll kind of ping pong back and forth between condo and homeowners association law as we go through this presentation. And you'll see on the top, I will direct you to the top of the slides. It will identify what we're talking about. Here is a condominium slide regarding fiduciary duty. So you'll see here in the first bullet point, this is a quote directly from the Florida Condominium Act that provides that as required by the Florida Not-for-Profit Act, as I mentioned, 617, an officer or director must discharge their duties in good faith with the care of an ordinarily prudent person in a like position would exercise under similar circumstances, and in a manner he or she reasonably believes to be in the best interest of the association. That is really the key here. So, you know, if you're on the board, are you going to be personally liable for, you know, a little mistake that occurs or some simple negligence that you made a mistake and it was not intended, it was not criminal? No, you will not. An officer or director acting in their capacity as such for your association, condo specifically says, will not be liable for monetary damages personally unless you essentially breach your fiduciary duty and it constitutes a violation of criminal law, a transaction from which you derived an improper personal benefit, or if you act recklessly or in a way that was in bad faith with a malicious purpose or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. So let's sort of break this down. If you are on your board or you're an officer and you violate the criminal law in your capacity as such, you could be personally responsible. If you are an officer director who derive an improper personal benefit from your position, and we'll get into that specifically later on what that really means, you could be personally liable. And this third one, you know, we never really got into these too much, but as we all sit here today, unfortunately almost a year out from Surfside, we really have sort of more focused on these in terms of building maintenance, what you know, what you don't know. If you act in a manner that is exhibiting wanton and willful disregard for human life or safety or property, that could also be some type of activity for which you could be personally liable. So those are really the nuts and bolts of the fiduciary duty for a condominium association. I will also mention on these two slides, there are specific statutes regarding specific activity that they culled out where forgery of a ballot, theft, destruction of property, destruction of records, destruction of financial records are crimes. They have specifically included this now in the Condominium Act, although it may be somewhat unnecessary because these would be crimes whether this language is in the Condo Act or not. It is instructive, it is guidance, it is emphasizing to all of the associations out there that if you take part in these type of activities, please be aware that those are crimes and they will be punishable and you will be breaching your fiduciary duty in that regard. So particularly important here are financial matters, where I think the one to focus on here is destruction or refusal to allow inspection of records or destroying financial records are going to be a huge problem for you. So I wanted to specifically mention this. Well, a long time ago now, it feels like it might be 10 years or so, we all know now that you have to be certified to be a board member. You have to take a course, which we have very frequently. We provide those. You've probably seen me give the condo board certification course. I do like to give that course, or the HOA board certification course, and that's a requirement. In order to be further apprised of your obligations and understand what you're doing running this corporation, you're required to, within 90 days, either take this educational course or certify that you have read your documents, you will uphold the documents, and once again, key language here, that you are going to faithfully discharge your fiduciary responsibility to the association membership. And this language is the exact same in the HOA Act. So when we get to that, I'll probably skip over it. And I will mention that this is serious. You know, we hear this all the time that Mr. Jones didn't take his course, didn't sign the certificate, and therefore, you know, that's a breach of fiduciary duty. Well, I don't know if that's the case, but you have to take these actions in order to move forward on your board and be certified to do so. I'll mention that in the past, I want to say at least 2 to 3 legislative sessions, we've seen proposed changes to these board certification requirements, where they have proposed that every board member be required to take the course and or be required to execute an affidavit attesting to the fact that you've read the documents, that you will work to uphold the documents, and that you will faithfully discharge your duty. While that has not become law, I suspect that there will be further efforts to put that through, and that, you know, we will possibly see some changes to this because education is key. I mean, there are so many different statutes and requirements that you have to comply with in a condo. And as we see, associations are very frequently named as defendants in lawsuits. So you want to set yourself up here that no one can point to you that you didn't comply with your duty. And that really the first step there is to comply with this board certification requirement. Here we have the same thing for homeowners associations. You'll note that there is not as express language in the HOA Act as to fiduciary duty issues. In other words, we don't have as much text here in the HOA Act, but that's pretty typical. The HOA Act is usually more brief on certain matters than the Condo Act, but it does clearly provide that the officers and directors of an HOA, homeowners association, have a fiduciary relationship with the members who are served by the association, and it's right there in black and white. We see unit owners point to it all the time, and you need to be aware that that's there. Similarly, we have the exact same language regarding the 90 days after being appointed or elected. You need to become board certified. You want to set yourself up to not have some attack that you did not complete this and you are not you are not, being a good fiduciary here. So I would definitely recommend that you comply with that law. And, you might want to take the course every year. The law, I'll go back one slide, provides that you only have to take this course or sign the certificate one time if you serve on your board without interruption. But, it's not a bad idea to take these courses more frequently. We offer them all the time. So do other providers. So I would strongly recommend that you don't blow it off and that you learn as much as possible, because there is just so much to learn here regarding condos and HOAs. And if you've seen us year after year, the laws change so frequently. We did not have any legislation during this year, 2022, but 2021, we had a lot. Years past, there were a lot. So it's always constantly changing. And sometimes there's little subtle issues that are, incorporated into the acts where you need to be up to date. So please stay up to date if you are a board member or manager, really. Okay, back to the slide. Homeowners associations here. We have a specific statute, once again, to further draw your attention to, crimes related to the operation of associations. If you've been charged or you've been indicted with felony theft or embezzlement, you're going to be removed from the board. And that's a good thing, I suppose, that they specifically put that into the act, because as you may be aware, once you get on the board, the only way to get off the board, besides resignation, you move out of the community, is a recall. The board members typically can't remove other board members. So if you have somebody who's done these type of activities, this statute acts to automatically remove them, at least temporarily. Okay, so when you're acting as your director, as an officer, you need to act in the best interest of the association, but you're not an expert in every single different area, that you incorporate into your service here. You're probably not an engineer. You're probably not a landscape architect. You're probably not a lawyer. And if you were, you wouldn't want to be representing your community anyway. So you're probably, you're not an accountant. So if you are relying on a professional in good faith as a board member, and something goes wrong, you rely on your engineer's report to do certain work, and something goes wrong, there's a problem, there's a claim, you will not be out. You will not be personally liable. So I underlined the last bullet point here. A director is not going to be liable for any action taken as a director or failure to take any action if they perform the duties in compliance with this section. So if you rely on your expert reports, that is going to sort of get you off the hook in the event of some kind of problem down the road. However, if you are that lawyer, or if you are that engineer, or if you just are a really smart person who has a lot of knowledge about a lot of subject areas, and you know that some kind of expert report or document that is provided to you is incorrect, or that the full picture wasn't given to the professional in order to provide that report, that could bring you out of the safe harbor that you usually have for the liability. So if you know that something is not correct, you can't then try to use your expert as a shield. So I will mention that as well. One thing I will also mention on this slide, because I think it's important and it relates to a lot of the building maintenance issues we are dealing with right now, is that once you do get that report, that engineering report that says you have a structural issue on stack 2, you can't bury that report. You have a reasonable amount of time to deal with it. Once you get that report, you can't just bury it in a file cabinet somewhere and never come back to it and ignore it. What you can do, and what we see sometimes similar to legal issues, is you can go ask another professional for a second opinion But you have to act reasonably here. Once you get expert opinions, you cannot frankly ignore them. Do you have to deal with it the next day? No, but you have to deal with it in a reasonable amount of time. That's what I would say there. Okay, so just very, very briefly going to managers. Manager statute right here, 468.4334, the professional standards of managers. They're your agent. They're the agent of the corporation. They act for you. So we do have the professional standards here that provide that a manager has to discharge their duties loyally, skillfully, and diligently, and dealing honestly and fairly in good faith with care, and this is the important part, full disclosure to the community association. So in the event your manager proposes to do something that could be deemed or perceived as a conflict, they're not necessarily prohibited from doing that. If they want to go work for a board member, if they want to go work for an owner, or if their husband's company wants to bid for your landscaping job, that's typically more likely here. That is not completely prohibited, but they have to disclose that relationship to you. So that's important to note. We do have that quite frequently where we see, a manager's family member wanting to provide services because of the connection. And sometimes these are, just ease of service. It just makes sense. And there's really benign. There's not a whole lot going on there, but they do have to disclose that to you. So I think that is very important to know. The last bullet point on here, just be aware that the manager statute provides that managers cannot be indemnified for their gross negligence. So that relates to their standard of care. They can't be grossly negligent, they can't be reckless, they cannot act in bad faith with a malicious purpose, or similar to this other statute I mentioned, in a manner exhibiting wanton and willful disregard of human rights, safety, or property. So that also relates to manager activity. Do association officers or directors receive a salary or compensation for the job? Is this part of the job? I said you're running a company, you're the CEO, you're the president of this corporation, and it sounds like a fancy title, but we all probably know that that is not the case, or we would have a lot more people running for our boards. And, of late, I guess we've seen some contested elections, but many, many associations who I've worked with over the years have the same board, forever, because we hear all the time the colloquial phrase, it's a thankless job, and sometimes it is. And, I think all of us know that, a salary and compensation is not part of this, or else we would see a lot more people probably wanting to get in on it. Some very large associations might be paying their board members because country clubs or a very large POA, because they are hired people and it's authorized by the bylaws. So here, how do you get compensation as a director? You don't take it from the operating account. You don't tell your manager to cut you a check, because that is not authorized. The statute provides for a condominium that, unless otherwise provided in the bylaws, the members of the board shall serve without compensation. Unless otherwise provided in the bylaws, the officers shall serve without compensation. So if you can get a bylaw amendment approved to pay the board, I suppose that is going to be okay. I've really never seen that other than in the instance of a very, very large POA where you essentially have paid board members running the business. In 720, HOA associations, very similar. We have an officer, director, committee member may not directly receive any salary or compensation from the association for the performance of their duties, and may not otherwise benefit financially from service to the association. So this is all kind of common sense, but 720.30312 was amended a while back now to specifically address this and to port over kind of some of the principles from the Florida Not-for-Profit Corporate Act directly into the HOA Act. So we can all see them, we can all point to them. But it's kind of nice here in the HOA Act that they did provide for some exceptions that come up kind of frequently. We're not going to go over all of these because I won't be able to finish in time, but I'll mention, reimbursement for out-of-pocket expenses incurred by the person, subject to the approval of the board. Basically, if you have typically happens in a smaller association, if you have a board member who's in residence all the time and he or she is gracious enough to sort of do some of the admin for your association, they go to Costco and they buy toilet paper and other goods and they want to get reimbursed. That is an exception specifically here in the HOA Act. Obviously, we want to have internal controls regarding all of that. That's a big thing with your auditor, where if you have that type of thing going on, you need to have processes to make sure that it runs appropriately and that this is being approved by the board. But sometimes you might even have an emergency situation where the board member has to go out and put something on his credit card because you can't get a hold of your accounting department to cut a check. Well, in that instance, the board member should be paid back, and that is not considered compensation or a salary. We also have any fee or compensation authorized in the governing documents, any fee authorized in advance by a vote of a majority of the voting interests. So we have some guidance here, I would say, in the HOA Act to say you're not typically allowed to have a salary or compensation, but these things, A, B, C, D, E, F, are not a salary. So that is nice to see. Okay, specifically here, we're getting specific now. I mentioned you cannot have an improper personal benefit from your service on the board. You didn't get on the board to get yourself services from vendors. And why do I have this picture of landscaping here? Because a long time ago, I was involved with an association where they were hiring a new landscaper, and that happens all the time. I feel like I never hear associations happy with their landscaper, but I am a lawyer, so I always get the problem. I'm sure there are great landscaping companies out there. So we have this association, they hired a new landscaping company, and then it was brought to the attention of the board afterwards that the president who sought out this vendor and got the contract had all new mulch in their yard. So I'm not exactly sure whether the president paid for the mulch or not, but it was asserted that he got that as a benefit for getting that vendor in the community. So he essentially got what we hear as a kickback, and that is completely improper. And that is a pretty explicit example of the improper personal benefit issue, but we sometimes see other little more subtle improper personal benefits. And one of them that comes to my mind is where you have a board member who calls the attorney, such as me, because this happens sometimes, not very often, where we have a relationship because he or she is the president of the board. I speak to them regarding association business, and then they call me up and they want to have me help them with their own personal problem, really, at no cost, or I'm not going to bill the association, but you can't try to get services by using your role in the association and finagling them. I can't be providing you with a benefit. I can't be writing a letter for you or analyzing something for a director, because I would consider that an improper personal benefit. So the specific statute right here we have for condos says an officer, director, or manager may not solicit, offers to accept, or accept anything or service of value or kickback for which consideration, which is a monetary payment generally, has not been provided for his or her benefit or that of their immediate family from anyone providing services to the association or proposing to provide services to the association. If that occurs, the officer, director, and here we have manager actually, is subject to a civil penalty, and it could be a criminal issue as well. There is an exception in the Condominium Act. This does not prohibit an officer, director, or manager from accepting services or items received in connection with trade shows. So a lot of you probably go to these events, because I know you do, because you're here listening to the course. So you're probably the type that go to the trade shows and go around to the booths and maybe put your card in the basket and you win. Some of these people give out pretty good prizes, a TV, a trip, a gift card, a gift certificate for a restaurant. So that is not going to be considered an improper personal benefit for a condominium association. What about lunch? What about lunch? Is there a free lunch here? Not for condos. There's nothing about, accepting lunch or dinner or food or beverages at a business meeting, unlike the HOA Act. So the HOA Act here specifically now, we have similar language. You are not allowed to solicit or offer or accept goods, services for which you did not give consideration, i.e. pay for. But we have a little bit of a different exception here. You can accept food to be consumed at a business meeting with a value of less than $25, or a service or good received in connection with a trade show educational program. So I always like to make a joke here, because it says food, it doesn't say beverage, and $25 is not that great of an amount. So I say you can get lunch but no dessert. So you will be able to go out to a meeting with a vendor, maybe that you want to talk about a project, and they pay for the lunch. If you're in an HOA, that's expressly authorized. If you're in a condo, it's not addressed, and I would definitely tell you to proceed with caution there and to not accept these type of treats, I guess, because it seems like it's not a big deal, but somebody's always going to try to point a finger at you, right? Everybody wants transparency, and everybody is really sort of on edge in the past couple years about these things. So I would tell you to be as cautious as possible there. We have next, interested transactions. Before we get to that, I saw a couple of the questions, and I said I wasn't going to take them, but I saw some at the very beginning that I wanted to just address before we got too far, and I think we're doing pretty good on time. So we have a question. We have a resident that owns a graphic sign company, a resident now. Is there any conflict of interest in using the residence company to replace or update the community signage? No, there's no conflict if you want to have a resident act as a vendor, other than a very specific circumstance that relates to condos, which we'll get to at the end. In a HOA, if the bylaws and statutes preclude spouses from being on a committee, okay, no, we're not going to do that one. So I just wanted to get to the first one about unit owners, lot owners proposing to provide you with services. And generally speaking, that's okay. That is not a conflict. And we typically get that question very frequently. Another question that we get pretty frequently is it a conflict for a board, for the board to use a vendor who is also used by a board member? So the board member uses a landscaping company. We'll use this landscaper. We'll continue, and we'll say it's a HOA. The board member uses ABC Landscaping Company, and they do a great job. They've been their landscaper for 10 years. They're a big company. The board member proposes that since ABC is so good and has provided them with good service, why doesn't the association use ABC? So that would be fine. That would be totally fine, unless that board member got a discount, got a benefit, got free services for referring that vendor to the association. So that would be okay as well. So now we're getting into interested transactions. I kind of thought that this was sort of like double dipping. You can't have your cake and eat it too without proper approval. And the next slide is a statute that was actually just repealed effective July 1, 2021. We used to have a statute in the Florida Condominium Act, 718.112.2p, that was a complete prohibition on board members providing services to the association. It said an association, which is not a timeshare, may not employ or contract with any service provider that is owned or operated by a board member or any person who has a financial relationship with the board member or their relative. So this was a complete prohibition on board members or their family members providing any type of service to the association for payment. Well, this statute came in, I don't know, a couple years, 5 years ago, 6 years ago, and we all kind of scratched our heads because there's another statute, which I will click on right after this, that was a direct conflict. So we had this statute that said it was a total prohibition, and then we had another statute saying that it was authorized under certain circumstances after you jumped through hoops. So I hope I made it clear enough that the total prohibition has been repealed effective July 1 in 2021, last year, and now we all can use the statute that was existing for some time, which is this one, where you can propose for a board member or maybe their company or their wife's company or their brother's company or somebody who they have a, you know, they're another financial interest with, to contract with the association, but it must be disclosed and you must go through a specific process to approve these type of contracts, and they have to be approved by 2/3 of the non-interested board members. So if you have a condo association with 5 board members and 3 of those board members are working for this vendor that the board wants to hire, you don't have 2/3 to approve it. So that's really a key here. So we'll kind of try to break down the statute a little bit. The statute provides that there are certain things that are going to be presumed as a conflict of interest. And I mentioned where the officer, director, or their relative has an interest in a company that is proposing to work for the association. In that circumstance, as I mentioned, that you will have to disclose this to the board in advance of the board meeting at which this is going to be considered. The board member shall be allowed to make a presentation regarding this type of activity. Then they actually have to leave the meeting for a condo now, where after they leave the meeting, it can be discussed, and then 2/3 of the non-interested directors can vote on it. So that's sort of how this process works. At the next regular or special meeting of the association, maybe your annual meeting, you're having a special meeting of the membership now. This once again has to be disclosed to the members, get up there and say, have an agenda item, disclosure of interested transaction contract, and it has to be put out there, I guess I would call it. And upon a motion of any member at the meeting, that contract can be canceled upon a majority vote of the members present. So the members then have the opportunity to cancel that contract. If the contract is canceled, the association has to pay up until the date of termination, but is not liable for any kind of cancellation fee, liquidated damages, or any other type of penalty. More text. This is very detailed here, right? We have the full picture. If you want to go back and read this after the course today, I won't go over all of this stuff because the clock is ticking, I guess I would say. But I already summarized this statute. I will say bullet point 5 here. If 20% of the voting interests of the association petition for the termination of that contract, that will also void the contract. So there's multiple opportunities for the board to consider this at a properly noticed meeting at which it's disclosed. There has to be a disclosure at a membership meeting, and then the members can take up a vote to void this type of arrangement. And it's voidable on the petition of at least 20% of the voting interests of the association. So we mentioned that these are contracts between the association and a director, but it could be the director's relative within the third degree of consanguinity by blood or marriage. So these relatives are going to be first, second, and third degree relatives by blood or marriage, including children, parents, brothers, sisters, half brothers, all these different people. So this gets a little bit complicated, and we typically don't see it brought out that far. And, it's usually more of a straightforward type of transaction. And, sometimes these transactions are very helpful, and I say they're benign because the board member can get you a better deal. It's not that they're trying to make money off of the association, they're actually trying to save the association money. So it's there's different schools of thought on this, but I was happy to see the complete prohibition removed from the statute and to have the board and membership given the authority to enter into these things that could benefit the association in some type of situation, but also have some control, some way to get out of it if it becomes a problem without owing, penalties to the vendor. Same thing for the HOA Act. We never had a complete prohibition about interested transactions in the HOA Act. It's very similar to the Condo Act concerning consideration of interested transactions. And the key really is you have to disclose to the board at that board meeting, and 2/3 of the other directors present have to approve the matter. At the next meeting, as I mentioned with condos, you have to bring it up and you have to allow the members to vote if they shall choose to do so. I've never seen that happen, but I have been at meetings where this has been disclosed to the members, and as you have to do, as you have to follow this law, and it typically is not that big of a problem. We're going to skip over that slide, because we are running out of time. Here we have, again, going to the Manager Act here, 468. The following acts constitute grounds for which disciplinary actions may be taken by the DBPR, the Department of Business and Professional Regulation, the agency that administers managers. Here we have contracting on behalf of the association with any entity in which the manager has a financial interest that is not disclosed. Once again, it's not a prohibition, it's a disclosure. Violating any provision of chapters 718, 19, or 20 during the course of performing community association management. So a lot of those statutes, which are very detailed, you go back and read this, get your highlighter out, incorporate managers into the obligation. So if a manager has violated a provision of 718, let's say, on a kickback type issue, then that would also be a violation of the manager statute that could subject them to disciplinary actions if somebody makes a complaint about it, right? Okay, special restrictions for condominium associations, not only large condos, the one that I put on this slide, but this really applies to all condo associations. Before I get to this slide, I wanted to mention one area that typically comes up for a lot of our associations: realtors on the board. Realtors on the board. Is that an interested transaction? If the realtor has a contract for a sale, they're on the board, they're proposing to, help submit an application, let's just say it's a condo, where they're going to obtain some commission out of this deal, right? It's proposed to the association, the background check is run. If you have the authority, you're in the phase of reviewing this application, you're in the phase of figuring out whether the board wants to approve this transaction. That's somewhat of a gray area. Should this board member be voting on their own deal? Obviously they probably want that to go through because they want to get their commission and be done with the deal and get the unit sold. But in my opinion, in my recommendation, that is a situation where it could be seen as some kind of improper personal benefit, interested transaction. So I would recommend that that board member take a step back. Don't be involved in that. Vote, abstain, because that is a situation where I do see people pointing fingers at a board member where they're somewhat involved in their own transaction where they are going to personally benefit. And since it is, I would consider it somewhat of a gray area. It's not really in the box here, but somebody could make a very good argument that you had an improper personal benefit there. So I would tell you to take a step back there, and that is not a good idea. On the other hand, if you're a board member who got on the board because you had an agenda. Everyone has an agenda. It doesn't mean it's a bad thing. It doesn't mean it's a sinister thing, right? That you wanted to get on the board because you think that pets should be allowed. You want to reverse the pet prohibition because you are interested in getting a dog. Is that a conflict of interest? No. You're lobbying for, your platform. That is not something that I've seen create a legal problem where you're lobbying for an issue that's important for you, where you're trying to put forward your platform to impose or eliminate some kind of use restriction. It might be a pet restriction. It might be related to leasing, right? That, you want to curb leasing. You want to allow leasing. And I don't see those type of matters as a conflict because it's not only relating to that director, it's relating to the entire membership as a whole there. So special provisions for condo associations, a maintenance or management service contract is not going to be valid. This is just a regular old maintenance management contract. You go out and get a manager. You get a proposed contract. That contract for a condo now has to set forth specific things and it has to be disclosed. All of this is regarding disclosure, if you haven't realized by now. Disclose, disclose, disclose. You have to disclose any financial interest that the developer has with the management company. You have to disclose any financial interest that a board member has with the management company, and that has to be in that contract. It has to be in that contract. If it's not, it could be deemed invalid and unenforceable. Special provision regarding condominiums, the last bullet point. If 50% or more of the units in a condo are owned by one party, if there's a bulk owner, right, and the bulk owner has a landscaping company, right, and they want to provide services to the association, this is not a board member. The bulk owner is just an owner. I said that was okay a couple minutes ago, but if you own 50% or more of the units in the condo, then you can move forward with it, but be aware that this gets you into the bucket of where the owners can cancel upon a majority vote. The owners can cancel that type of contract. So this isn't happening every day. There are many associations, this is unique, right? We don't see that many where one owner owns 50% or more, but it is there sometime. Let's see, specific provisions to associate condos. You cannot hire an attorney who also represents the management company. This is an important one. A board member, manager, or management company may not purchase a unit at a foreclosure sale resulting from the association's lien. So that's important to see. If you can purchase a unit at a bank foreclosure sale, but if you have sort of inside information and are calling the shots, you shouldn't be able to get the benefit of purchasing the unit, and really it's kind of an improper personal benefit, right? So that is an exception, all for condominium associations now. We don't see a lot of these specific examples in the HOA Act, but the examples could be instructive. So if you are in a HOA and you are a board member and you want to go bid at an association foreclosure, there's no specific prohibition against it, but somebody could say it's a breach of fiduciary duty. So we kind of use these things as instructive as HOA. It's not black and white, but it's instructive. So again, for condominium associations, a specific point here, An officer, director, or agent may not use a debit card issued in the name of the association and billed directly to the association. It's kind of like a weird statute, I would say, but you can't use a debit card. You could use a credit card. You could go out and get a gift card. I heard somebody say they got around this by, just as an example, they went to Home Depot, they bought a gift card for $200. They gave it to the manager and they said, use this gift card to purchase some minor supplies, bring the receipt, and that might be somewhat of a workaround there. Oh, wow, we did end a little bit early. So I'm going to go to the Q&A to see if we could answer some of these questions. Jacqueline has a question. Would a board member suing the association be considered a conflict of interest? No, that is not a conflict of interest. We see a lot of times people wanting to keep these people off the board. They say, oh, how could somebody run for the board if they're suing the association? That's not necessarily a conflict of interest, although they might be precluded from being in on some of the information. You don't want to give them information that's adverse to the association. It's not a conflict per se in terms of this type of course. Let us go to another question now. Let me try to read these very quickly. If an officer or board is being paid to maintain other owners' units, maybe, the board is acting to go check on owners' units while they're out of town. I think that's probably what you mean here. I don't see there as a conflict unless you're sort of using your role as the board to say that, you have to do it, to make some kind of rule that said only board members can be used as people who can check on apartments and they're entitled to payment. Yeah, no, that's not going to be a legit policy. That's going to be something not correct. Let me go here. Can the president of the board provide construction services to the association? Would this be considered a conflict of interest? Well, that was really what this course was about. That was right on the money, that question. I hope I answered that question. And they can provide construction services to the association for payment if it is properly authorized by, when we break this all down, 2/3 of the non-interested board members. I think that's really where the bottom line is there. After all the disclosures are made, yes, they can provide it. Is that the best thing to do? You'd have to evaluate that. Sometimes getting into business with people very close to you or people on the board just, leads to issues, I'll say. Is it technically a problem if it's done all correctly and in conformance with the statute? Maybe not, maybe not. What if the management company or a company brings lunch into the office for everyone, not just the manager? Well, if you're a condo, apparently that's, on the edge of a potential problem. This is Marley's question. But if you're a homeowners association and, a vendor brings in some donuts, the statute specifically authorizes that. So you'll be okay if you're a HOA. If you are a condo, then you might not want to take a donut. Let's see. If a board member, okay, we have another question. Can a board member use his position to purchase a condo unit? Where can I find that information? That's a very open-ended question, but we did touch on that. The board member cannot purchase a unit, a condo now, at the association's foreclosure sale. That does not relate to HOAs. There is no such parallel prohibition in the HOA Act. If a board member is a licensed CAM, do they still need to complete the board certification requirement? Yes, they wear two hats there. If you are a board member and a CAM, you need to comply with your board certification requirement. Definitely, I would recommend that. There is no exception if you're a CAM, but you definitely know a lot as a CAM, but you still need to jump through those hoops. And the more you learn, the better, right?
And I just want to mention, anybody typing their questions into the chat, we are not looking at the chat. Please use the Q&A and we'll get to as many as we can in the limited time left.
Okay, is it considered double dipping for a management company assigning work to contractors owned or operated by people that work for the management company? Lawrence, this was your question. It's not prohibited, but it has to be disclosed. A lot of the management companies have other arms, affiliate companies. They have restoration companies, they have restoration, they have landscaping, they have roof. And it's not necessarily improper, but it has to be disclosed. And a lot of the times, particularly with the larger management companies, if you go to the last page of that contract, they'll have a big bold language, disclosure. Our management company, the following companies are affiliates of our management company and may provide work to your association. So that is legit. What I would tell you to do if you're negotiating a management company, or just maybe you can make it a policy, right? As if a management company disclose, they have to disclose it at the beginning, right? But if they go out and get bids, they have to tell you again. When they give you that bid that is from their affiliate, at that time they say, hey, by the way, that this is our affiliate, and they have to get at least a couple, you have to usually get more than one bid. But if they're getting one bid from their own affiliate, then I would make them get 2 other bids, not only 1 other bid, just practically speaking, right? That's a practical advice there. Will we receive an email with all of this information? No, but you can download everything in the link in the chat. Richard Alexander, you had too many different questions. I couldn't read them all. I'm trying to kind of filter through to some of them that are more concise. Can a manager of a property management company contract with the condo to serve as PM? That seems pretty straightforward. The general manager of the property management company can work for the association. Yes, of course. I'm trying to, it's 12 o'clock, 12:01. So for those of you who want to get to your lunch or who are busy, feel free to log off. You will get they'll get a pop-up with all the information. They can fill it out and get the certificate, and we'll get your credit inputted as soon as possible. But I'll keep going on these for maybe another couple minutes and see where we go. There were so many questions, so it's good that I can at least answer a couple of them.
And before you get to just real quick, before you get to the next one, for those of you on the phone, tomorrow you'll get, everybody on this call, whether on the phone or not, you're going to get a follow-up email thanking you for your attendance. In that follow-up email, you'll have the same link to click on and fill out the evaluation. And after you fill out the evaluation, you can print your own or save your own certificate, because the confirmation screen forms the certificate. So that's the thing, is that if you're on the phone now, you're not going to see the link that pops up at the end. So for those calling in, again, look for that email tomorrow that contains the link everybody else will be seeing at the end. Back to you.
Okay, so quickly, because a few people asked about this, and we get this all the time. Co-owners on the board, co-owners, spouses on committees in a condo, in a residential condo of more than 10 units, co-owners cannot serve on the board at the same time unless they own multiple units or there was no one else willing to serve. In a homeowners association, there is no such law. In a homeowners association, spouses, co-owners can serve on the board at the same time. You can probably have somebody who owns, a family in a homeowners association that owns multiple lots comprise the entire board. So in a homeowners association, that is completely different. In committees, can co-owners or spouses serve on a committee together? That is a governing document issue. There is nothing in the law that would preclude that, but if you have an issue about that, you might want to amend your governing documents to specifically address it. Let's see here. Is it a conflict of interest if a board member is performing handyman work for a resident and accepting payment? No, Tammy, that was your question. Not necessarily. That was only if the board member somehow told this person that he or she was the only one available to do that work and they had to use them. So no, that is a sort of a perception issue that, it could be seen as a perception problem, but not necessarily. Same thing for your property manager. A lot of the time it's convenient to have the property manager, if authorized by contract and the board, do sort of side projects for board members or unit owners. We see that a lot. And that is not a technical conflict, but it might be something that you just don't want them doing because it presents problems. So if that's the case and you just don't want them doing that, then I would recommend that you have a contract or a policy, depending on the circumstance here and who they are, that is not something that's going to be authorized by the association. May licensed CAM owning and living in the condominium charge for his services? Yes, Jose, this is your question. If a resident wants to act as your CAM, as long as they're not on the board, you got to jump through all those hoops. But yes, you can contract with a unit owner who is living in the building. Is that the best idea? Maybe, maybe not. It just depends on the nature and what's going on in your community. But I've actually seen that work very well because they're there. They live there. Somebody can go knock on their door. I've also seen it work very poorly because you cannot, they're there. They're going to be there after that relationship falls apart and you'll have to all live together. So I would caution you in doing that, but it's not technically prohibited, but just evaluate the pros and cons, definitely. Let's see, I'm trying to filter through here. We'll give it a couple more minutes. We still have quite a lot of people on.
While you're perusing, I'll also mention in the chat, I just placed the evaluation link into the chat area for those of you who want to fill it out while you're listening to Allison answer the questions.
You know what? I think I've covered a lot of the questions that I can get through quickly reading. Some of these, if you write me a paragraph, I can't really read it that quickly and respond. But a lot of people had questions on the realtor issue or different forms of the same question. I hope I answered that during the course. And if you have some general question, don't get into specifics. Don't write a ton of information, and you want to email me if you need clarification on something that we discussed today without giving me very specific information. I can try to answer your email. For those of you who have attended my courses before, I really do try to get back to you unless you're asking me very specific information. This is educational. This is not really considered legal advice. So I can't provide legal advice to you regarding your specific association, but I can provide general information. So if you have some general question, not giving me everybody's name and details in your email, please write to me because I do try to respond. And I thank everyone for attending today, taking the time out of your day to listen to this and obtain more knowledge. And I hope to see you next time during my course. If you're interested in new legal counsel, we do offer free consultations. We can do via Zoom. So if you have specific legal issues that really just are not general and I just cannot answer them, maybe we can do a consultation. And of course, I'd love to speak to new clients. So contact me if you have the need for that. Thank you so much.